My name is Calista Leslie Miller, and I'm a senior at School Without Walls High School. I'm here in Arizona doing research for my senior project. The focus of my research has been on the problem of violence in Indian country, especially when concerning Indian women or children. This week, I visited a lot of Indian reservations. I visited Fort McDowell, Auction, Salt River, San Carlos Apache, Pascayaki, and Tona Odom. I selected Arizona because there are 22 tribes and Indian communities in the state. Reservation land makes up about 1/4 of the state. Some of these tribes are in urban areas like Phoenix and Tucson, as well as in remote areas in the state. During my trip, I visited examples of both.
We're located in southern Arizona. We're located southwest of Tucson. In the Pima County metropolitan area, there's probably over 1 million people in this general vicinity. And so we're in Pima County, and we're about 50 miles from the southern border. On the reservation, there are approximately 4,000 to 5,000 tribal members that live on reservation in tribal housing. The tribe has a government, and it also has some enterprises that employ people.
Just some background, I've been here for about 15 years. As part of my responsibilities, of course, we have a lot of crimes that involve domestic violence. And so I certainly have been involved in the prosecution of those cases. We also, as part of our responsibilities at the prosecutor's office here, we also work with dependency cases, which involve children who, whose parents have either engaged in some activity or have addictions or some other reasons where children have to be removed from the home. So in that regard, I've worked with women and children as victims quite a bit in what we do here.
Many of the ancestors of these tribal members lived here for centuries. Regardless of their location, they have many challenges: high rates of poverty, high rates of unemployment, alcohol and drug abuse, and high rates of violence. People of Native ancestry represent about 5% of the population in Arizona. Arizona has the second largest American Indian population in the United States, preceded only by Oklahoma. Having grown up in Washington, D.C., a city that earned the right to self-govern only as recently as the 1970s, I can't help but make the comparison to the lack of autonomy on our nation's reservations. Much like Congress oversees and sometimes interferes with the lawmaking process of the District of Columbia, Congress has tied the hands of tribal governments. They have left them unable to protect tribal members by preventing them from enacting laws and prosecuting all individuals who commit crime on their land.
With the jurisdictional issue, it depends on who it is. But if it's a non-native, we can't do it, of course, at this point in time. But of course, there's crimes committed there by Native Americans, and then we can prosecute it. So it depends on the circumstance, but it's handled by either us, the state, or the federal government.
Originally, I thought that VAWA, the Violence Against Women's Act, was a fix to the problem. But this week, I learned that that's not exactly true. VAWA has a lot of problems, and there is so much that it doesn't cover. Let's talk about some of these problems. Funding is the big one. It costs about $1 million to implement VAWA. Even though Congress passed VAWA, they didn't fund it. So tribes themselves have to figure out how to come up with $1 million. Many of these tribes are poor and don't have that kind of money.
If a tribe doesn't really have much of that infrastructure, it's probably going to be like at least $1 million proposition. An annual proposition, just to have the bare basics to implement these laws. And so the same issues that we tried to address when they signed the law, it's still true for 99% of tribes. Part of the problem is funding. And there has been some funding. In fact, the last appropriations that was just signed by the president includes some funding for this because it was unfunded when it was passed. And so this last appropriation has funded the tribes who are implementing the program. And I don't know when that will filter down or how it'll filter down, but it should happen this year.
Another problem is that VAWA only covers very few non-Indians. The victim and the offender have to be in an intimate relationship. The problem is, how do you define an intimate relationship?
Even that question itself is interesting, because what is a relationship to you might be different than what your daughter's definition of a relationship is.
For example, I talked to the Attorney General at the Pasquayaqui tribe, and he talked about a case that shows this problem.
Interesting. It was a pretty violent case. It was actually a same-sex couple case. An adult tribal male who was in a dating relationship with a African American from Oklahoma. He had a felony warrant for armed robbery, and he was living on the reservation in this tribal house with this tribal male. They were in a relationship. They had a sexual relationship, but they were still in the closet. They weren't out. It's different on the reservation. I think this is true for a lot of reservations. It's not. It's still a bit taboo, and so folks might know that you're in a same-sex relationship or you're gay or lesbian, but it's not really something that's open or talked about. If that non-Indian offender beat up the tribal member really bad. They were out one night. They were at a party, and they came back home, and they got mad, and he beat him up really bad. And we arrested him. And then the state of Oklahoma tried to extradite him for their case, because we had him held here, and we notified them. He initially said he was Cherokee. And we're like, okay, we got to call the Cherokee tribe to make sure he's not. Either way, we would have had jurisdiction. It went to trial. The defendant didn't make any statements. He denied being in a relationship, didn't really talk much. The victim said, yeah, we're in a relationship, we live together. We had some witnesses that say they saw them together, they saw them kissing and stuff like that. We presented all that to the jury, and they came back and said that there wasn't enough to establish that they were in a relationship. It might have been easier if there was maybe some text messages, I love you, or maybe a Facebook page that said they're in a relationship, or additional information to say, text message and saying I love you.
Does VAWA require a sexual relationship?
It requires an intimate relationship. And so what does that mean, And so people nowadays are like, well, yeah, we hooked up, but I wasn't in a relationship with them. And so maybe a person's hooking up for a number of weeks, but they're not exclusive and they're not in a relationship.
So it would be easier if they were Facebook official?
Exactly. Yeah, and it sounds crazy, but that's what you have to prove. Otherwise, you don't have jurisdiction. So even if they were in a quasi-relationship and there was some violence, you wouldn't have jurisdictions. And we thought we had enough. We had a witness testify. They saw him kissing at a dance. There was testimony that they lived together. He did his wash, cooked for him. They rubbed lotion on each other's backs, and they had a couple of sexual encounters. But the defense was pretty good, and they said, look, just because someone comes to my house and I have a roommate doesn't mean we're in a relationship. Just because people have sex doesn't mean they're in a relationship. And that's maybe totally opposite from maybe 10 years ago, 20 years ago, but it's reality. And it was really disappointing, but on the flip side, it kind of shows that our process, our arrest, our trial, and due process for the defendant occurred, which it shows the system works. That's the silver lining. I've talked to the victim since, and he's still traumatized. He still has flashbacks at his house where this occurred. So I feel really bad that we weren't able to bring justice for him. And VAWA really didn't. VAWA includes same-sex couples, but I don't know that it kind of contemplated that it would be occurring right off the bat.
Another problem with VAWA is that it only covers adults. So what about the children who are victimized?
I think if you think about the non-Indians who live on reservations, they are essentially community members because they're living on the reservation. They've got children. In the 20-some cases we've had, there have been 18 children in these homes witnessing violence, actually being assaulted themselves. We haven't, because the jurisdiction only covers the relationship and the partner in that relationship, we were unable to prosecute for the crimes committed against the children.
An additional issue is that it has to be an actual physical assault. So what if it's a threat, damage of property, or anything besides a physical assault? It's not covered.
So there's a lot of gaps, and there's a lot of things that we're finding out right now and trying to address.
But here's the catch. If the tribe has not passed VAWA, they have absolutely no jurisdiction over any non-Indians committing crimes on their land towards their people. So VAWA is a step in the right direction because there's this slight place where tribes have jurisdiction, but there is this huge jurisdictional gap. As a part of the pilot project, 3 tribes began prosecuting non-Indians under VAWA in 2014. These 3 tribes were Paskiyaki in Arizona, Umatilla in Oregon, and Tulalip in Washington. It has not always been the case that tribes did not have jurisdiction over non-Indians. In the past, jurisdiction over any and all individuals on reservations belonged to tribal governments. However, over time, the federal government started to take over and control criminal jurisdiction. Indian nations increasingly fell under federal domination, which led to a significant loss in jurisdictional control over their own tribes. Finally, in 1978, the Supreme Court held in Oliphant v. Squamish that tribal courts did not have criminal jurisdiction over non-Indians unless Congress gave them that authority. According to the Supreme Court, when the Indian tribes located on this land were discovered by Europeans in the 17th century, they lost some degree of their sovereignty. One part of the sovereignty that they lost was the ability to criminally prosecute non-Indians. In the end, tribes should have full jurisdiction over any person committing a crime on their land, whether that's non-Indian or Indian.